Counsel.
Yes, sir. My
Yes.
Lord,
Yes. Yes, registrar. Registrar. Registrar.
I muted myself. I'm here, my lord.
I said we lost Mr. Robert.
Oh. My
We
lord is
lost
still
Mr.
online. I heard him.
He's not online.
Oh. It's true, my lord. It's true.
I can't see him. He has gone off.
He has gone off, my lord.
Gone offline. So let me stand it down, then call the case for judgment.
Yes, my lord. NICN ABJ 231-2017 between Onyereri Favor and British Nigeria Academy. My lord, the parties are absent.
sorry, my Lord.
Yes, we stood down your matter. We are on another matter.
As the court pleases. It's network problems, sir. We are sorry about that.
This case is for judgment. The judgment is ready and it's going to be delivered virtually now.
As the court pleases.
By the general form of complaint dated 25th day of July 2017 and filed on the same date, the claimant commenced this suit against the defendant seeking for the following reliefs. They are as follows. I have captured the reliefs, so I need not to read them. I will skip reading the reliefs. Upon being served with the originating process commencing this suit, the defendant on the 18th day of September 2017 entered appearance and filed a statement of defense. In the statement of defense, the defendant incorporated a counterclaim against the claimant. In paragraph 44 of the statement of defense, the counterclaim is hereby reproduced. I have reproduced the counterclaim, so I will skip reading it. The case of the claimant is that the claimant testified as CW1 after identifying his witness statement on oath. He adopted same as his evidence in this case. Thereafter, he was cross-examined by the counsel for the defendant and he was discharged. Likewise, the defendant called the vice principal of the school who testified as DW1. He tendered document in evidence and thereafter he was cross-examined by counsel for the claimant and he was discharged. The submissions of let me say from the onset that when this matter was adjourned for adoption of final written addresses, the defendant filed his final written address, but the claimant refused and neglected to file his final written address. However, on 26th of this month, that is day before yesterday, the counsel for the claimant decided to file his final written addresses, which is out of time, and there was no application for extension of time to file the said application out of time or to regularize it. However, being an address and not which is meant to assist the court in determining the matter, I shall overlook the irregularity and still look at the said final written address. Likewise, the defendant filed their own final written address out of time. They have not moved the application for extension of time. They fail and refuse and neglected to move their application. Therefore, their own final written address was also irregularly before the court. However, having said that, having taken into consideration the importance attached to the address, I shall overlook the said irregularity. However, both counsel have to pay for the default fees which they have refused to pay. The submissions of counsel for the defendant formulated 4 issues for determinations. They are: 1, whether the termination of claimant's employment by the defendant is lawful. And if the answer is in the negative, the issue number 2 will be whether, apart from the damages, i.e. 1 month salary in lieu of notice, naturally resulting from the breach, if any, the claimant can claim any form of damages whatsoever or at all. Issue 3, whether, considering the evidence before this honorable court, the defendant is entitled to its other claim, or in the alternative. 4, whether, considering the evidence before the court, the claimant is entitled to C, D, E, and F, other heads of claim enumerated at the various paragraphs of the claim. The argument on the 4 issues have been captured in the body of the judgment, so I will skip reading the argument. I now go to the submissions of the claimant. The claimants also formulated 4 issues for determinations. They are: 1, whether the termination of claimant's employment by the defendant followed due process and in accordance with the terms and conditions of service in the staff handbook, which regulates the employment relationship between the parties. 2, whether the claimant was given fair hearing before termination of her employment by the defendant. 3, whether the termination of the claimant's employment was unlawful. 4, whether the claimant is not entitled to damages, all her outstanding entitlements and the claims for the hardship and the inconveniences suffered due to the unlawful action of the defendant. Whether the defendant, having failed to discharge its obligation, the claimant can be entitled to any claim and damages against the claimant. The argument on the 4 issues formulated by the claimant have been captured in the body of the judgment. So I shall proceed to delivering my decision on the case put forward by the parties. I have considered the processes filed in this suit, the evidence laid by the parties, and the final written addresses of the parties. From the facts disclosed in this suit, I am of the opinion that 2 issues can dispose of the claim and counterclaim before the court. The issues are: 1, whether the claimant in this suit has proved entitlement to any of the relief sought from the court. 2, whether the defendant is entitled to the grant of the relief sought by way of counterclaim as per the pleadings and evidence adduced in support before the honorable court. However, before considering the main issues for determination, let me say that when this matter was adjourned for adoption of final addresses, I was transferred to Calabar Division of the court. Consequently, I returned the case file to the Honorable President of the court for reassignment to another judge. but the case file was returned to me to conclude since trial has been completed and what remained was adoption of final addresses and judgment. Therefore, on the 14th day of December 2022, the defendant filed motion on notice for extension of time to file final written address of the defendant out of time and a deeming order to deem the already filed statement final written address as properly filed and served. The claimant on its part did not file her final written address and did not file any until 26th day of April. That is 2 days to this day. They filed their final written addresses without even an application to regularize their position. On the 2nd day of December 2021, this suit came up for adoption of final written addresses despite being served with the hearing notices electronically. Parties and their counsel refused to appear before the court. The case was then adjourned to 20th day of January 2022 for adoption of final written addresses. Again, on the 20th day of January 2022, parties were not in court despite being served through their counsel with the hearing notices. On the 1st of February 2022, when this matter came up for adoption of final written addresses, again, parties and their counsel were also not in court. Consequently, the court deemed the defendant's final written address, which was the only written address then filed, as having been argued and adjourned the case to today, 28th day of April 2022 for judgment. However, on 26th of April 2022, the claimant decided to file their final written addresses, but without any application to regularize. But having considered the importance of final written address, I overlooked the issue of irregularity and deemed the said final written address as having been argued. In the circumstances, the addresses of the counsel have been deemed to have been argued before me, and they will be used in determining, they will also be used in determining the issues for determination. Coming to the main issues for determination, on issue 1, whether the claimant has proved entitlement to any of the reliefs, the law is well settled that he who asserts has the onus of proof. It is after proving the assertion before the court that the pendulum will tilt. A claim in an action is circumscribed by the relief being sought. Therefore, the duty of the claimant is to adduce evidence that can prove the reliefs being sought. The law is well settled that a claim is circumscribed by the reliefs claim, and the duty of the claimant, therefore, is to plead only those facts that are materials and necessary to sustain the reliefs and adduce evidence to prove same. See the case of Gabriel Atibi versus Cable Motel Nigeria Limited, reported in 2008, 10 Nigerian Kilo Report, Part 1095, page 399. The claimant in this case is suit is seeking for declaratory and other reliefs regarding the wrongfulness of termination of her appointment, and also interest on the monetary aspect of the judgment they are seeking for. The reliefs being sought by the claimant can be categorized into claim for wrongful termination, payment of salaries from the date of termination to judgment, payment of deductions from contributory pension, payment of unpaid leave allowances for the period of the claimant served the claimant, for the period the claimant served the defendant, 1,000 from the date the claimant was allocated accommodation, which amount to the total sum of 35,000 naira as caution fees. There is also the claim for injunction, restraining the defendant from evicting the claimant from her accommodation. There is also the claim of 20 million naira as general aggravated and exemplary damages. A declaration also is being sought that the claimant is not indebted to the defendant to the tune of 2 million naira. I shall start considering the reliefs being sought by the claimant. In relief A, which is for declaration that the termination of claimant's employment is unlawful or wrongful, the relationship between the parties being that of master and servant or employer-employee, the contractual agreement embedding the terms and conditions of service is binding on the parties. This stems out from the freedom of contract, which carries with it the inevitable implication of sanctity of their contract. Therefore, if any question arises with respect to the contract, the terms in any document which constitute the contract are invariably the guide to its interpretation. See the case of Efeta versus Shell, reported in 2005 4 SC Part 2, page 136 at 145. It is settled that when an employee has complained of wrongfulness of termination of his appointment, he has the onus of placing before the court the terms of the contract, empowering the terms of contract or employment before proceeding to prove the manner the said terms were breached by the employer. It is not the duty of the employer, who is a defendant in the matter, to prove any such breach as laid down by the Supreme Court in many decided cases, particularly the case of Amon versus Amode. See also evidence, Exhibit CW1A, letter of employment, and Exhibit CW1B 1 to 39, the staff handbook of the defendant. These two exhibits form the terms and conditions of employment of the claimant with the defendant. The defendant had in its final written address reproduced some content of Exhibit CW1A. Reference was also made to Article 83 of Exhibit CW1B 1 to 39, the staff handbook and termination of appointment. The defendant has argued that the termination of claimant's employment followed due process, as claimant was asked by Exhibit CW1H to vacate her official residence, and she will be paid all her entitlement or all the money owed her. As pointed out earlier in this judgment, parties are bound by the terms of contract, and these terms should be read as they are without any embellishment. So once the parties entered into a contract, and on no account should terms extraneous to the contract or on which there was no agreement be read into the contract. See the case of Attorney General of Rivers State versus Attorney General of Akwa Ibom State, reported in 2011 3 SC. See also the case of Ua and another versus Akpabio and another. See also the case of Koki versus Magnuson. See also Union Bank of Nigeria Limited versus BU Ume and Sons Limited. Termination of employment would be lawful if the terms and conditions of the contract of service between the parties are complied with. A combined reading of Exhibit CW1A, Exhibit CW1B 1 to 39, more particularly Article 7.2.4 and Article 8.3, will reveal that the defendant has the unfettered right to terminate the employment of the claimant, provided the stipulations in the terms and conditions of service are complied with. That is to say, notice, 1 month's notice is given or payment in lieu of notice is made. The position of the law is that either party in a master and servant may bring to an end the relationship subject to giving of the requisite notice or making necessary payment in lieu of notice under the terms of contract. Once either of this is done, a servant employee cannot complain of wrongfulness in termination of his or her employment. See the case of Akimpe versus UBA PLC. See also SPDC Limited versus Solar Rewaju, and the case of Ogan versus Nigeria Liquefied Natural Gas. Before determining whether the defendant in terminating claimant's appointment has complied with the terms and conditions of service, I shall at this juncture determine the German issue of the length of notice required for termination of the claimant's employment. This is necessitated by the apparent conflict that emerge from the conditions of service. Exhibit CW1A provided for 3 months notice, while Article 8.3 of Exhibit CW1B provided for only 1 month notice. In Exhibit CW1A, for termination of employment to be valid, 3 months notice must be given, or payment of 3 months notice must have been paid to the claimant. While in Exhibit CW1B 1 to 39, Staff Handbook by the Article 8.3, the claimant is to be given only 1 month's notice or payment of 1 month notice in lieu of 1 month salary in lieu of notice. Exhibit CW1B, it is to be noted that Exhibit CW1B is of general nature. It contains provisions that are of general application, while Exhibit CW1A contains specific provisions that applies to the claimant only. It is not a general, it is the provisions of Exhibit CW1A being provisions that are of specific nature will definitely prevail over the general provisions contained in Exhibit CW1 1 to 39. This means that for the notice of termination of employment of the claimant to be valid, the claimant must be given 3 months notice or payment of 3 months salary in lieu of notice. In view of the foregoing finding, the termination of the claimant as per Exhibit CW1H is wrongful, since the requisite notice for termination of employment has not been complied with. There was no 3 months notice given to the claimant, and there was also no payment of any salary in lieu of notice that was made to the claimant. The argument of the defendant that as per Exhibit CW1H, the claimant was asked to vacate his accommodation, vacate her accommodation for her to be paid all her entitlement cannot hold water. It is a thoughtless argument, as there is no provisions in the terms and conditions of service making such stipulation as conditions before payment of entitlement can be made. In any event, the termination is still wrongful, since there is no evidence of payment in lieu of notice was made contemporaneously with the termination as enjoined by the law. See the case of Chukuma versus Shell Petroleum Development Corporation Limited. In view of my finding, I hereby declare termination of the claimant's employment as wrongful. A relief B is for declaration that the claimant was not given fair hearing and adequate opportunity to defend herself, given the allegation relied upon by the defendant to terminate her employment. The claimant stated that no committee has been set up to try her. Exhibit CW1H, which is the letter of termination, did not state the reason why claimant's employment was terminated. Therefore, the claimant is not entitled to this declaration, since no reason was adduced for the termination. Relief C is for an order compelling the defendant to pay claimant her outstanding salaries of 39,968.40 kobo per month from February 2017 till this matter is finally determined by this honorable court. This relief presupposes that the claimant is still in the employment of the claimant, that is, his employment still subsists. By Exhibit CW1H, the employment of the defendant was terminated with effect from 10th of February 2017. This means whether the termination was proper or not, wrongful, or as found by this court, the employment remains terminated. This is because court cannot enforce willing employee on unwilling employer. Once terminated, the employee ceases to be employee of the defendant. The employee cannot treat his employment. The employee cannot treat his employment as still subsisting. See the case of OFO versus NNPC, WAEC versus Oshinebo, and the case of Sunday Joseph versus Kwara State Polytechnic and others. Therefore, a servant whose employment has been terminated cannot claim for salary for the period he is no longer in service. See the case of Spring Bank PLC versus Babatunde. See also the case of Obot versus CBN. In view of the principles encapsulated in the foregoing decisions, the claimant in this suit cannot claim salaries for the period he was not in service or from the date of termination of his appointment to the date of this judgment. However, having shown that the claimant was in the service of the defendant from 1st to 10th of February 2017, he is entitled to claim salary for the period of 10 days only and not for the whole of February, since he only served for 10 days. I so find and hold. Relief D is for an order compelling the defendant to pay claimant the sum of 380,198 naira 98 kobo as being her total pension contribution deducted from her monthly salaries and not remitted into her retirement savings account. To prove non-remittance of the pension deduction, the claimant tendered Exhibit CW1I, a document from Stanbic IBTC pension managers showing registration details of the claimant, and Exhibit CW1F, claimant statement of account for the period of 1st January 2011 to 4th of January 2018, which shows no remittance has been made into the retirement savings account. From the evidence before the court, the defendant has admitted not paying or remitting the claimant's pension into her retirement savings account. The reason given by the defendant is that the claimant did not supply details of her retirement savings account. Going by the provisions of Pension Reform Act, where an employee has failed to offer retirement savings account, the employer is duty bound to offer retirement savings for the employee and remit the employee's pension into the retirement savings account. The defendant in this case has failed in its duty to try by not opening a retirement savings account on behalf of the claimant and remitting the claimant's pension into the said account. The defendant has also stated that it started operating pension contribution scheme in 2014. This cannot be the correct position. The Pension Reform Act was enacted and came into effect as far back as January 2004, and the claimant in this suit joined the defendant in 2012. If, as at 2022, the defendant has not begun implementation of the provisions of Pension Reform Act with respect to its employee, the defendant is in breach of the law and liable to pay for such failure to follow the law. I therefore find and hold that the claimant is entitled to have pension entitlement from the date of the employment in 2012 to 10th day of February 2017, when her contract of employment was terminated. The claimant has stated that the sum of 380 being claimed by the claimant as her total pension contribution stood at the sum of 380 naira 4 kobo. According to the defendant, there was no pension deduction from 1st of March 2012 to February 2013, as the period covered probationary period to bear the consequences of appropriate deduction from claimants from criminal salary. The defendant must bear the consequences of all inaction or failure to do what is opposite to do, what is supposed to do. I have examined the calculation of pension contribution made by the claimant as shown by paragraph 11 of the statement of facts and paragraph 11 of the witness statement on oath of CW1 and that of the defendant as shown in paragraph 10 of the statement of defense and paragraphs as shown in paragraph 10 of the statement of defense and paragraph 17, 18, 19, and 20 of the witness statement on oath, 15% and 18% pension as appropriate. I found claimant's calculation to be the correct calculations. I therefore adopt it for the purpose of this judgment. The calculation by the defendant was incorrect and it omits the period of probation. The Pension Reform Act did not exclude period of probation from pension deduction. Therefore, the omission of the period of probation cannot be justified. From the foregoing analysis, the claimant is entitled to the sum of 988 and 98 kobo as pension deduction from his salaries and employer's contribution for the period the defendant served the defendant, for the period the claimant served the defendant. Though the claimant is entitled to her pension, the payment cannot be made directly to the claimant, for the simple reason that the said payment is by law to be made into the claimant's retirement savings account. In the circumstances, I hereby ordered the defendant to remit the sum of 380 as pension deduction from his salaries, from her salaries and employees' contribution for the period the claimant serves the defendant. Though the claimant is entitled to her pension, the payment cannot be made directly to the claimant for the simple reason that the said payment is by law to be made into the claimant's retirement savings account. In the circumstances, I hereby order the defendant to remit the sum of 380 on the claim for the sum of 180 as leave allowances as provided for in the staff handbook exhibit CW1B 1 to 39. The defendant has, however, not disputed this claim, has not denied, has never contended that it has paid the claimant's leave allowance. The defendant has, however, disputed the total amount the claimant is entitled to as leave allowance. According to the defendant, the claimant is only entitled to 3 years leave allowance at 18,000 per year, amounting to the sum of 54,000. I quite agree with the claimant that he is entitled to 4 years leave allowance, and I refuse to accept the assertion of the defendant that the 4th year was not complete. The reason being that by doctrine of arithmetical approximation, once a number has exceeded half, it is approximated to the whole number. Therefore, the claimant having served the defendant from 1st of March 2016 to 10th of February 2017 has, by the doctrine of arithmetical calculation, served for a whole year. Therefore, she is entitled to payment of 4 years leave allowance. The 180 claimant's basic salary per annum is the sum of 18,000 naira Therefore, 18,000 naira the 180,000 claimant's basic salary per annum is the sum of 18,000. 18,000 multiplied by 4 will give us the sum of 72,000. That is what the claimant is entitled to as leave allowances for 4 years. The next relief is refund of the 1,000 naira deduction amounting to 35,000 naira as caution deposits. For the defendant, the arrangement was for the claimant to occupy the apartment for a year and rent her own apartment because she was being paid rent allowance. But the claimant refused to vacate the apartment. The cautionary peace policy of the defendant was introduced so as to ensure that if an employee left the apartment in a deplorable state, the sum deducted as caution fees will be applied to mitigate the cost of the maintenance. None of the parties in this suit has tendered any document evidencing the agreement of the parties regarding the allocation of the apartment to the claimant. The defendant, the court is left in the dark as to the terms and conditions for the use of the apartment. What is clear from the evidence is that the apartment was allocated to the claimant to occupy temporarily for a year. According to the defendant, thereafter, the claimant is to look for another accommodation to rent on her own. What can be deduced from the evidence of the defendant is that the claimant occupied the accommodation in question with the permission of the defendant. In view of the absence of any documentary evidence on the allocation of the apartment to the claimant, can the claimant claim refund of the caution money deducted directly from her salary? I shall start by considering the caution, what it meant by caution deposit or fees or deduction means. The Cambridge Dictionary online access at HTTP on 24th day of April 2022, it defined caution deposit as an amount of money that someone has to pay when they rent property, use a service, etc., which will not be returned if they damage something or owe money at the end of their contract. Each new student is required to pay a caution deposit of certain amount of money. A caution money, it is clear from the above definition that caution money requires to be paid is in respect of rented property to serve as security for ensuring that the tenant or occupier does not damage In the case at hand, the claimant occupied the property of the defendant by virtue of her being staff in the employment of the defendant. Therefore, as soon as the claimant ceases to be employee of the defendant and upon vacating the property, the cautionary money deposited or paid by the claimant will become refundable, provided that the claimant did not cause any damage to the property. The claimant has in evidence before the court asserted that the property was not in a habitable condition when it was allocated to her, while the claimant maintained that the claimant left the property in a deplorable condition, but there is no evidence on the damage caused by the claimant to the property. In the circumstances, the failure by the defendant to establish by evidence In the circumstances, I find that the claimant is entitled to refund of the cautionary deposit in the sum of 35,000 naira. I so hold. Relief G is for order restraining the defendant from evicting the claimant from the house. This relief is overtaken by event, considering the fact that the claimant has already been evicted from the apartment. To make matters worse, the defendant had, while this suit is still pending before this court, evicted the claimant. The attitude of the defendant in this case is highly condemnable. How? The conduct is meant to subvert the course of justice. Relief H is for an order compelling defendant to pay claimant the sum of 20 million naira as exemplary damages for the inconvenience, frustration, and embellishment and embarrassment caused by the unlawful or wrongful termination of the claimant employment. The court has found that the termination of the claimant is wrongful. This means that the damages recoverable by the claimant from the defendant for the wrongful termination of her employment should be the amount of money for the period of notice, which is per Exhibit CWA is 3 months salary in lieu of notice. See also Onongo versus NNPC. See also Nigerian Produce Marketing Board versus Adeomi Reprint. See also Ipeta versus Shell. See the claimant monthly salary as at the time of wrongful termination is 15,000 naira times 3 will be equal to 45,000 naira. This is what the claimant is entitled to as salary in lieu of notice. The defendant is hereby ordered to pay the claimant the said amount. Relief I and J have not been proved by any evidence. In the circumstances, they are hereby refused. Decision on counterclaim. The second issue for resolution is whether the defendant is entitled to grant of relief sought by way of counterclaim as per the pleadings and evidence adduced in support with to the counterclaim. The defendant counterclaim, the relief being asked is in the alternative. Therefore, the court will first and consider the mere relief. It is when the mere relief could not be granted that the alternative claim will be considered. In line, it is to be noted, I have earlier in this judgment found that termination of claimant's employment was wrongful due to lack of requisite notice or payment of salary in lieu of notice. In the circumstances, this court cannot grant the counterclaim in respect of validating the termination of claimant employment, since the court has already found that employment to have been invalidly terminated. On refund of 340 as the alternative prayer, which the claimant has denied being indebted. This has cast onus of proof on the defendant to establish his counterclaim. The defendant, apart from testimony of DW1, it has not tendered any documentary evidence showing the amount paid to the claimant, which she is claiming refund. In fact, the defendant has stated in its pleading and evidence that the accommodation was allocated to her temporarily for a period of 1 year, but at the expiration of 1 year, claimant refused to forget the property of the claimant. The defendant, why was the claimant as employee of the defendant not being sanctioned for refusing to carry out lawful orders or for insubordination? Furthermore, the duty to deduct rent from employee's salary is on the employer. If the employer has refused or neglected to make such deductions, what it means is that the defendant has allowed the claimant to stay in its accommodation free of any charge. I came to this conclusion when the claimant has allowed the claimant to remain in the said accommodation for 2 good years and 10 months without raising any qualm to such occupation. The details default is on the determination of claimant's employment was done by the defendant for no reason, so the defendant will not be allowed to benefit from its own wrong. The alternative claim is for the sum of 2 million naira, being the rent value of the accommodation which the claimant was occupied. Till termination of her employment, I consider the evidence of DW1 on this claim as speculative and figment of imagination of the witness. The reason being that DW1 has not told this court how he got the said figure, and based on what therefore DW1 cannot give evidence regarding the rental value when he has not been shown to be a professional in that field, and no valuation report was tendered to have corroborated whatever evidence he may have given. In the circumstances, the defendant fails to convince the court of his entitlement of this relief. Relief spirit of the counterclaim is for the sum of 66,670 naira per month from February 2016 till claimant vacates and a tenantable and habitable. This claims is overtaken by Ben. There is no evidence before the court that, despite pendency of this suit, with the prayer seeking order restraining from all I have been saying, the claimant has succeeded in some respect in proving some part of his claim, while the defendant has failed woefully to establish his counterclaim. For avoidance of doubt, the order of the court are as follows. 1, the termination of claimant's employment is hereby declared wrongful for having not been done in line with the conditions of service. Furthermore, there was no recommendation by any disciplinary committee for the termination of employment of the claimant as required by the conditions of service. The defendant is hereby ordered to pay the claimant the sum of 45,000 naira as 3-month salary in lieu of notice. The claimant is entitled to the refund of the sum of 35,000 naira. The defendant is hereby ordered to pay claimant 45,000 as 3-month salary in lieu of notice. The claimant is entitled to the refund of 35,000 naira deducted from his salary as portion deposit. The claimant is also entitled to the sum of 72,000 being his unpaid leave allowances for 4 years. The claimant is entitled to payment of salary for 10 days from the first day of first to 10th day of February, when the claimant's employment was terminated. The defendant is hereby ordered to calculate and pay the claimant salary for 10 days from 1. I put the cost of this suit at 1 million naira. The defendant is hereby ordered to pay the claimant the sum of 1 million naira as cost. All monetary aspects of this judgment shall be complied with within 30 days, failing which interest, 10% interest per annum shall apply. Judgment is entered accordingly.
As the court pleases.
Yes, the matter stood down. Recall the matter that was stood down.
Yes,
As the court pleases, sir. My Lord, may we
Recall
read
the
29,
matter that
2020.
Yes.
Suit number NICN CA 29-2019 between Mr. Efioku Okokun Asuko and Lafarge Africa PLC. My Lord, they are absent. Parties are absent.
Yes, counsel, same appearance.
Yes, sir.
Yes.
Yes, my Lord, before we proceed to adopting our processes, may I utilize this opportunity to thank my Lord for that erudite judgment, sir.
You are welcome.
And we pray that the Almighty Allah continually to protect you and lift you to
Amen. Amen.
the apex of your judicial career, sir.
Yes.
Amen.
Okay,
Yes.
sir. Our written address, consequent
Yes.
upon conclusion and closing of our case on the 6th of December 2021.
Yes.
The defense filed our final written address.
Yes.
Dated on the 8th of December 2021 and filed on same date, sir.
Yes.
And consequent upon service of the claimant's final written address on the defendant
Counsel,
on the 23rd of December 2021.
Counsel, have you filed soft copy of your address?
Yes, sir. They filed their final written address on the 16th of December 2021.
Yes.
I mean, have you filed soft copy of your address?
Yes, sir. Yes,
you
sir.
know, order 45 requires you to file the hard copy together with soft copy.
Yes, sir. We have done that, sir.
Registrar, can you confirm?
Yes, my Lord, he did.
Okay. Yes.
Yes, my Lord.
Yes, counsel.
Went upon
Yes, can we
service
make
on us
progress?
of the claimant's final written address.
Yes.
On the 23rd of December 2021, we filed our reply on points of law out of time.
Yes.
On the 11th of January 2022, sir.
Yes.
And same was regularized by a motion on notice
Yes.
dated the 7th of January 2022, but filed on the 11th of January 2022, sir.
Yes.
But granted by you, sir, on the 22nd
Yes.
of March 2022.
Yes.
On the strength of that, sir, we adopt our final written address
Yes.
and our reply on points of law.
Yes.
As our argument in support of our defense.
Yes.
And we urge you to hold, sir, that the claimant has failed to prove his case against the defendant.
Yes.
Furthermore, sir, on the strength of Order 45,
Yes.
Rule 7
Yes.
of the extant rules of this Honorable Court 2017, sir.
Yes.
We urge you to deem the claimant's final written address as adopted, sir.
Yes.
And adjourn this matter for judgment. We are most grateful, sir.
Yes. This case is hereby, the claimant's final written address is hereby deemed as having been argued. This case is hereby adjourned to 17th of June 2022 for judgment.
As the court pleases.
Sorry,
I know
sir,
17th June is a Friday.
Okay, then 16.
My lord, 7th.
Which would be,
yeah, 16, my lord. It's 16, my lord. 16 is as the court pleases.
As the court pleases, sir.
It's adjourned to 16th of June 2022 for judgment.
As the court pleases.
As the court
We are most
pleases.
grateful,
Okay.
sir.
Thank you very much, counsel. You are welcome.
Yes, sir.
Registrar, call the next case.
My lord. Yes, my lord. Suit number NICN ABJ 232-2017 between Rita Ostava Lemba and British Nigeria Academy. My lord, the parties are absent.
This case is for judgment. The judgment of the court is ready and it's going to be read now.
As the court pleases.
On the 25th day of July 2017, the claimant took out a general form of complaint against the defendant for the following reliefs. The reliefs have been captured in the body of the judgment, so I will keep reading them. Upon being served with the originating process commencing this suit, the defendant filed a statement of defense and incorporated in it a counterclaim. The counterclaim has been reproduced in the body of the judgment, so I will keep reading it. The case of the, I have also given a brief facts regarding the case of the claimant and that of the defendant. Then I go to the submissions of the defendant. The defendant formulated 4 issues for determination. They have been produced in the body of the judgment. The claim issues have been reproduced. Canvas a record of those issues have also been reproduced. I now proceed to the decision of the court. I have carefully perused the processes filed in this suit, the evidence adduced by the parties, and the final written addresses of the parties. The claimant failed. The claimant failed and neglected to file its final written address within the time stipulated by Order 45 rules of the rules of this court. In fact, it was after the adoption of the final written address and the case has been adjourned for judgment that on the 26th of this month, the claimant filed its final written address. This means that the claimant's final address is not regularly before the court as they are for extension of time to regularize the position of the claimant or to file the said final written address out of time. However, in view of the importance of final written address, I shall overlook the irregularity and consider the said final written address. However, I am of the view that 2 issues are sufficient to determine the issues before the court. The issues are whether from the evidence adduced by the claimant has proved its entitlement to any of the reliefs being sought. 2, whether from the evidence adduced by the defendant is entitled to counterclaim. Issue 1, whether from the evidence adduced by the claimant has proved entitlement to any of the reliefs being sought. In determining this suit, I shall consider the relief being sought vis-a-vis the evidence adduced to see whether the claimant has established entitlement to the claim. The law on the proof is that he who asserts must prove, as claimant must rely on the strength of his case and not on the witness of the defense. I have noted Before proceeding to determine the twin issues, I note that both parties have used the word dismissal and termination interchangeably. However, it is to be noted that contrary to the practice in other jurisdictions of the world, our labor jurisprudence makes a distinction not just between dismissal and termination, but also as between wrongful termination, wrongful dismissal on the one hand, and unlawful or void termination, unlawful or void dismissal on the other hand. See the case of Alhaji MK versus First Bank of Nigeria PLC, where Obuanya JCA has this to say: termination or dismissal of an employee by the employer translates into bringing the employment to an end. Under a termination of appointment, the employee is enabled to receive terminal benefit under the contract of employment. The right to terminate or bring to an end employment to an end is mutual in that either party may exercise it, while dismissal, on the other hand, is a punitive and depend on contract of employment very often entails loss of terminal benefit. It also carries an unflattering opprobrium to the employee. End of quote. See also the case of CBN versus Igbilo. See also the case of Benue Cement Company PLC versus AGA. It was held there that there is a distinction between mere wrongful dismissal and an invalid or null dismissal. The distinction is that where the court makes a finding of wrongful dismissal, the payment in lieu of notice will apply. But where the finding is that of dismissal or termination was null and void, there is no dismissal or termination, as what the employer did was a nullity before the law, in which event reinstatement can be ordered. Also, in the case of Union Bank of Nigeria versus Suarez, and the case citing the case of Adeko versus Ijebu Ode District Council, it was held that there is a clear distinction between termination of contract of employment and a dismissal. Termination gives the parties the right to determine the contract at any time by giving the prescribed period of notice. Dismissal, on the other hand, it is disciplinary measure which carries no benefits. It is clear from the facts of this case, since there is no disciplinary measures taken in terms of setting up of disciplinary committee, the action taken cannot be said to be within the purview of dismissal. In fact, DWAA said it all, that the claimant's employment was terminated and not dismissal. Now, coming to the determination of the claim of the claimant, Relief A is seeking for declaration that the dismissal of the claimant's employment by the are wrongful in an attempt to prove the against the claimant did not follow due. In an attempt to prove the case, the claimant submitted that the defendant did not follow due process. The claimant stated that she was dismissed from employment of the defendant orally and no letter of dismissal was issued to her. The defendant, on the other hand, asserted that the claimant was dismissed in writing. DW1, who testified on behalf of the defendant when questioned under cross-examination, has stated that there is a letter of dismissal of the claimant and the letter is in her file. From the evidence before the court, it is clear to me that claimant was not served with the letter of dismissal or termination of her employment, but she got wind of the dismissal or termination. That's why she stayed away from work. It is to be noted that though the oral termination is deprecated, it nevertheless ended the contractual relationship. The employer has a choice of services of her employee, expressly or impliedly. See the case of OFO versus NNPC. Therefore, termination or disengagement of employee can be done orally or in writing or by conduct. See Ifeta versus Shell. It is to be noted that for employer to disengage his employee, all she need to do is to ensure compliance. With the conditions of service. In the case at hand, there is consensus that the conditions of service are as encapsulated in Exhibit CW1A 1 to 40 and CW1B 1 to 2, which are the staff handbook and letter of employment of the claimant by the defendant, Article 7.24 of Part 7 on discipline, provided that termination shall be on approval of the director of the school, principals, or recommendation of the disciplinary committee set up to deliberate on the matter. Also, Article 8.3 of Part 8 of disengagement provide that termination of appointment of any employee at any time shall be subject to 1 month notice in writing or payment in lieu of notice. Still on termination, Exhibit CW1B 1 to 2 in page 2 provides that the appointment will be probationary for a period of 12 months, after which satisfactory completion of the probationary period on permanent appointment. Determination of the contract of service by either party is by 3 months written notice, which must coincide with the end of an academic term. The claimant in this case has served out the probationary period of 12 months. She is a permanent employee, in which case her termination must be by 3 months' salary in lieu of notice. There appears to be conflict between the period of probation as provided in Article 8.3 of Exhibit CW1A 1 to 40 and that of Exhibit CW1B 1 to 2. Taking into consideration the fact that provisions of Article 83 is of general application and that of Exhibit CW1B is specific only applicable to the claimant, the provisions of Exhibit CW1B shall take precedence over provisions of Article 8.3, which are general in nature. The Latin memo is specialibus non derogat. See also the case of Guamase. From the above exposition of the position of the law, it will be right to say that the termination of claimant's employment to be proper and valid, claimant must be given 3 months notice of termination or be paid 3 months salary in lieu of notice. The position of the law is that either party to master and servant relationship may bring the relationship to an end, provided the requisite notice has been given or payment in lieu of notice. Once that has been done, the claimant cannot claim that his employment is still subsisting. See the case of Akimpe versus UBA, SPDC versus Olarewaju, and Organ versus NLNG. A look at exhibits DW1AA, letter of termination, will show that claimant was not given requisite notice and was not paid 3 months salary in lieu of notice. On that score, the termination of the claimant's employment is wrongful. It was not validly done by the defendant, as there was no notice and no payment of salary in lieu of notice. Even the payment in lieu of notice, if it has to be effective, it has to be made contemporaneously with the termination. See the case of Chuku versus Shell Petroleum. In view of the foregoing finding, I hereby declare that the termination of claimant's employment is wrongful and the claimant is entitled to damages which shall be her 3 months salary, The claim for salaries from 1st March 2017, the judgment presupposes that the claimant is still in the employment of the defendant. The claimant, as stated, got wind of termination Consequently, she stopped going to work. This means from the date the claimant got wind of termination, she ceases to be staff of the defendant. Therefore, she cannot claim salaries for the period she was not in the service of the defendant. It is right to know that an employee cannot reject termination or dismissal from service and regard his employment as still subsisting. See Wayek versus Washene Bob. Therefore, the claimant is not entitled to salaries for the period she did not render services to the defendant. See Springbank versus Babatunde. On Relief 3, which is for the sum of 98,000 naira, mere outstanding pension contribution the part in support of this in paragraph 10 to 12 of the Statement of Facts and Review 1. The claimant is period of probation, i.e., 16th April 2013 to 16th April 2014. According to the defendant, the claimant became entitled to the contributory scheme in response to the claim for pension. It is not the sum of 98. According to the defendant, the balance is not up to 98,000 naira. The defendants, however, did not refute the allegation that the pension, not all the pensions have been remitted to the pension fund administrator. The Pension Reform Act envisages contribution by both parties, since no deduction has been made from the claimant's salary between March to 14th to 2013 to 14th to April 2014. The claimant cannot claim any entitlement. It was further stated that the claimant, in addition to the claim, was on probation, that it was from June 2015 that the defendant commenced deduction of 8% contribution. The deduction was 7.5 instead of 8. Let me say here that the Pension Reform Act is as amended, is applicable to both private and public sectors. It is compulsory for every employer of labor having a staff strength of 50 employees to key into the scheme. The assertion of the defendant that it is in 2014 that the defendant joined the pension scheme and commenced deductions cannot be correct. The position taken by the defendant is on false premise. As pointed out, pension reform is binding. Pension Reform Act is binding law on employers of labor. The defendant refused to key in at the commencement of the law in 2004. It is clear that the defendant is in violation of the Pension Reform Act by not joining by not joining or paying contribution or deducting contribution on behalf of its members. I have examined and calculated the pension contribution of the claimant as shown in paragraph 10 of the Statement of Fact and 10 of the witness statement on oath, and that of the defendant in paragraph 21 and 22 respectively. After the calculation of the 15% and 18%, I found claimant's calculation to be correct. Therefore, the calculation made by the claimant was correctly done and it shall be considered for the purpose of this judgment. The Pension Reform Act did not exclude period of probation from pension. Therefore, the commission of the period of probation cannot be justified. though the claimant is entitled to her pension, the payment cannot be made directly to her because by the law it is to be paid to the pension fund administrator into her retirement saving account. In view of this, I hereby order the defendant, to pay the pension entitlement of the claimant into her retirement savings account with her pension fund administrator. Or relief E is for an order compelling the defendant to pay the claimant the sum of 72,000 as being her leave allowances for 4 years. The only dispute between the parties in respect of this is the issue of payment from April 2016 to March 2017. The period served by the claimant is for 11 months. This cannot be. Therefore, the defendant is of the view that since there was no service for complete year, claimant will not be entitled to the leave allowance for that year. Since there is no dispute as to the claimant's 10% of our basic salaries is a sum of 24,000, which this amount times 3 will give us 72,000 as claimed. Relief succeed and is hereby granted. Relief F is for order compelling defendant to refund to the claimant the sum of 17,000 naira, being deductions for caution deposit. The defendant has submitted that the caution deposit is not refundable, while the claimant is of the view that it is refundable. Generally speaking, caution deposit is required to be made in respect of rented properties or for services. The caution deposit is refundable if at the end of the caution deposit there was no damage to the property. The caution deposit is returned to the owner. In the whole gamut of the evidence adduced before the court, there was no iota of evidence to show anything was damaged by the claimant. Respecting the accommodation officially allocated to her, the period she served for the defendant, in the absence of any credible evidence proving any damage to the property the claimant occupied, the claimant is entitled to refund of the caution deposit made from her, deducted from her salaries in the sum of 17,000. The defendant is hereby ordered to pay the claimant 17,000 naira, being deductions for caution. Or relief G, this relief has been overtaken by event since the claimant has been ejected out of her property. Since the claimant's employment was found to have been wrongfully terminated, is for damages, which is for salary for the period Nigerian lines the law laid down in the cases cited above. The assessment of damage for wrongful termination of employment, as in this case, the claimant is entitled to 3 months' salary in lieu of notice as damages for wrongful termination of employment. Relief I and J cannot be granted as no evidence has been adduced to prove those reliefs. I now go to the decision on the counterclaim, which is covered by the second issue for determination. It is to be noted that a counterclaim connotes a cross-action, a claim for reliefs aside on original claim had been made, but that is the defendant's claimant in opposition to or as set off against the claimant's claim. It is reasons of convenience. A counterclaimant has a duty to prove his counterclaim, as the failure to do so will mean refusal of the counterclaim. Has to be proved to the satisfaction of the court by the claimant, by the defendant counterclaimant. And standard of proof is same with the proof of the main claim, which is on preponderance of evidence. See Ignobia versus Abofa, see Nu versus Commercial Farms, see Nal Merchant Bank. In line with the above well-established principles of law, I shall continue centers on declarations. Declaration for termination of claimants found the reliefs, the defendant counterclaimant has failed woefully to prove that the claimant's termination was validly done, as it was made in violation of the conditions of service. No notice was given, no payment in lieu of notice, and there any misconduct. A refund of the sum of 146,000 naira rent, the claimant is entitled to this amount, is not entitled to this amount, having regard to the fact that the claimants, despite being aware of the pendency of this case, went ahead to obtain an order to evict the claimant from the accommodation when there is a prayer for restraining the defendant from evicting the claimant from the accommodation. Therefore, the defendant cannot be allowed to benefit from its own wrong. It cannot be allowed to benefit from its own wrong. There is also a claim in the alternative for 750 B rental value. The witness of the defendant, DW1, is not a specialist, and he has never told the court that he is well versed in the area of property. There was also no valuation report tender to establish that the value of the property in controversy is what is being claimed by the claimant. So the failure of the defendant to adduce concrete and cogent evidence to establish the actual value has deprived this court from granting these reliefs. The defendant willfully failed to prove entitlement to this head of claim. It is also my view that the claim for rent must fail due to evidence before the court that despite pendency of this suit, with a prior seeking order restraining the defendant from evicting the claimant went ahead and evicted the claimant, forcibly evicted the claimant from her property, from the property she is occupying. From all I have been saying above, the claimant succeed in fact, while the defendant willfully failed to prove any of the reliefs in the counterclaim. For avoidance of doubt, the orders of this court are as follows. The termination of the claimant's employment is hereby declared wrongful, and claimant is entitled to payment of 3 months' salary in lieu of notice. The defendant is hereby ordered to pay the claimant the sum of, to pay the claimant 3 months' salary in lieu of notice. There is the claimant 17,000 naira being cautionary deposited with the defendant or deducted from claimant's salaries. The claimant is entitled to the sum of 72,000 naira unpaid leave allowance for 4 years when the defendant claimant to counterclaimant failed to establish entitlement to any of the reliefs being sought in the counterclaim. The counterclaim is hereby dismissed for lack of proof. Cost in the sum of 1 million naira is hereby awarded in favor of the claimant against the defendant. The all monetary aspect of this judgment must be settled within 30 days, failing which 10% interest per annum shall apply. The total sum for the pension shall be paid into the claimant's retirement savings account by the defendant. Judgment is entered accordingly.
As the court pleases.
Yes, Registrar, thank you. We have come to the end of today's proceedings.
Thank you, my lord. Thank you, my lord.
Okay.
My lord, happy Salah in advance.
Okay, thank you very much. I appreciate it. Have a nice day. My regard to your family.
And you too, my lord. They will hear, my lord. Thank you, my lord.
Okay. Administrator, you can end the sitting.